Hello, my name's Dwayne Johnson, and tonight I'm your host for The Last Gavel Heard. Tonight we will be reviewing the case of Jonathan Ferlack, a young web designer who has recently found himself in the Supreme Court. Jonathan Ferlack claims that his First Amendment rights to free speech have been violated. Tonight we'll explore this from experts and also an Occupy protester who we met on the street. Jonathan Ferlack was arrested on October 20th, 2011, on Wall Street in front of a Citibank building where he and his fellow Occupy Wall Street protesters were staging a protest against Citibank, and all banks in fact. They held a sign that said death-to-banking.com and shouted at Citibank employees, "You have sinned against the working man." Is this speech legal? Did Ferlack really disturb the peace? Did he present a clear and present danger that would warrant his arrest? Let's find out.
Jonathan Ferlack is an innocent man. His speech clearly conveyed an idea, and during his protest he did in no way display a clear and present danger which warrants his arrest.
Look, it's a simple concept. When there's imminent violent speech out there, the government should regulate it, period.
Jonathan Ferlack, one of the founding members of the Occupy Wall Street movement, staged a protest in front of a Citibank building. He and others held a sign publishing the URL to his website, death-to-banking.com, and followed Citibank employees 15 to 20 steps behind them shouting, "You have sinned against the working man." Citibank employees complained to the police who monitored the protest for 2 days without an arrest. On the third day, Officer Carlos, who was monitoring the protest, visited Ferlack's website, death-to-banking.com. The website's homepage, which has since been shut down by the Department of Justice, contained a picture of a burning bank and the phrase, "Burn all bankers." Officer Carlos arrested Ferlack immediately after viewing this webpage. The principles of the issues present in Mr. Ferlack's case go back to 1919, when Charles Schenck of the Socialist Party of America distributed flyers urging people to resist the draft for World War I. After Schenck had been arrested under the Espionage Act of 1917, Schenck appealed his case all the way to the Supreme Court, where he was opposed unanimously. The opinion written by Justice Oliver Wendell Holmes, Jr. stated, "The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger."
If that definition of a clear and present danger is used, any language could become a clear and present danger to society. Using that definition in this case, someone could be arrested for expressing displeasure for someone, something we all undoubtedly do. What makes something a clear and present danger is specifics. I think we can all agree that expressing displeasure for someone is protected speech. It should be protected speech.
The second critical precedent in the case tomorrow is Chaplinsky v. New Hampshire, which established the precedent that speech labeled fighting words, which do not convey legitimate ideas, were not protected under the First Amendment.
There is, however, a difference between saying something like, "I don't like Ben over there, I think he should die," and "I think we should kill Ben next Tuesday because he makes me angry." I think most people have said something similar to the first statement, and it should be protected. Intent is a big issue. The statement, "Ben should die," lacks intent to do any harm, while "we should kill Ben next Tuesday" has a clear intent of imminent action.
The final precedent the Supreme Court justices will surely consider is Brandenburg v. Ohio. Brandenburg was arrested after inviting a television station to a Ku Klux Klan event, making a speech targeting blacks and Jews. The Supreme Court held that Brandenburg's speech incited violence and therefore it could not be protected.
In the decision for Brandenburg v. Ohio, a test was set up to determine a clear and present danger. The test states that there needs to be intent, imminence, and likelihood. Ferlack only showed slight intent, an intent to incite emotions and rally more people to protest, and that is completely legal.
Do you think that Officer Carlos made the right decision?
100%. His duty, first and foremost, is that of the police officer. The thousands of workers in the Citibank building trust police officers like Officer Carlos to protect them from any kind of threat. Now, I think that he assessed the threat correctly. If you're a police officer, put yourself in those shoes. You have those thousands of lives at risk and in your hands, and you see violent messages directed towards them, and you see violent images directed towards harming those people. What are you going to do? Are you going to stand idly by and risk those lives, or are you going to preempt that violence and disable that threat? I think he acted just as I would want any police officer to do in that situation. He assessed the threat and he disabled the threat.
What I don't understand is how could he have assessed the threat properly if he only spent 10 seconds on the website?
Look, police officers are entitled to act on their judgment in the moment. You know, hindsight, they say, is always 20/20. In the moment, you see a burning building, and you have protesters who are potentially violent and could have a bomb on them, and who are directing you towards content that says, blow up this building. How long do you have to wait before you think to yourself, here's a burning building, and here's potential violence, should I stop it? The answer is, not much more than 10 seconds. We should be patting him on the back and congratulating him that he can assess threats quickly. Those 10 seconds in a different situation could have meant the difference between a bomb going off and a person being arrested and that threat being disabled. He made the right decision, and we should applaud him that he made it fast.
So do you think that internet speech and speech in person should be treated equally?
Absolutely not. My personal belief is that they are far different. Internet speech is the new speech of our age. It's the new defining technology. And as such, it's more complex and it's more nuanced. You know, on the internet you can post something thinking it's private, but the second later it's public. It's a different medium to communicate through. And as such, I think it should legally be treated differently. There's a legal frontier that we haven't addressed yet and that we haven't explored at the Supreme Court. You know, the last ruling they even had to do seriously with internet was back in 1999, which was Reno versus ACLU, which set the precedent that internet speech is exactly the same as written speech or spoken speech and is therefore protected in the exact same manner as those two are by the First Amendment. I don't think that's the case. I think that they are fundamentally and substantially different, and that the Supreme Court needs to establish and have a new ruling that sets forth the relationship between the internet and the First Amendment. Because, frankly, right now it's very murky.
How do you think the government should treat the internet?
I think that the government should strive to regulate it as little as possible. I don't think that they should stick the federal, clumsy government fingers into the internet and create a whole mess. I think it probably makes sense to have some, copyright protection measures in place, and also probably makes sense to shut down very extreme terrorist websites that are spreading information about how to make a bomb, or, information that should not be out there in the public. I think the government has a right to clear that stuff away from the internet. Aside from that, I think it should be mainly kept unregulated and as a space where people can post and share their opinions without the fear of Big Brother looking down on them. Hopefully, in this next case, the Supreme Court agrees with me, but we'll see as time passes.
Thank you so much for coming on, sir. I really appreciate it.
Thank you, and I very much enjoyed the conversation.
Now we have a special Occupy protester to give his view on things.
Hi, my name is William, and I'm from Tennessee, and I think that the common man's voice should be heard on this issue. I firmly believe that we need to free Ferlack as soon as possible. Along with all of the Occupy Wall Street members, I want to emphasize that we are not a violent contingent of people. Rather, we have political beliefs that need to be understood. However, the police force, the politicians today, and the corrupt financial institutions are trying to stifle our voices, to make it so that we cannot share our vital information about their corruption. Now, what has happened in Ferlack's case is absolutely atrocious. These are peaceful citizens, I repeat, peaceful citizens who are just trying to get their opinions out there to the public. However, there is a conspiracy happening between the New York Police Department and the officials at Citibank. They have conspired together in backroom deals made in the Citibank building to shut down Ferlack. The whole webpage fiasco, all of that is part of the conspiracy. They are posting on there anonymously to make the webpage seem more violent. Let me repeat myself. The Citibank officials are responsible for many of the posts on the Death to Banking website. Therefore, they are trying to influence this case in an undue way. This opinion needs to be heard. We need to take down that 1% whose foot is on the throats of the rest of the 999%. Now you in the media, I know you're going to spin this. You're going to spin my interview to make it seem like I'm just saying nonsense. But I'll tell you from the bottom of my heart, this America of the United States is corrupt and needs change and needs more people like the Occupy Wall Street protesters. That is all I have to say on this issue. Thank you.
Well, that's all for tonight. I'm Dwayne Wayne Johnson. This has been The Last Gavel Heard, and thank you very much for watching.